Just give it a minute to let everybody join us from the lobby.
Yeah.
Right, good morning, everybody. I'll keep allowing people in, so if you just bear with us for a minute or so. Just as an introduction before we kick off for the speakers we've got today. So firstly, I'm Sarah Birkinshaw from Quest Consulting. We're a full service HR company and obviously talking lots to our clients about the many changes that are coming up in 2026 and into 27. So I'm delighted to welcome not only our very own Lisa Jones, who's one of the senior consultants here, who's going to talk through this morning some of the practical steps you can plan for these changes, but also our legal partner, Nick Wilson, who's from Robinson Ralph, if I can put my teeth in this morning. And Nick's one of the partners there. And so we'll be walking us through what these key changes are. So Lisa, I'm going to hand over to you and Nick for the slides. One thing just to mention for everybody, if you do have any questions, please use the Q&A. And if we've got time, I will come to them or answer them. If we don't have time in the hour that we've got, then we will respond to you post-meeting. So Nick, over to you.
Thanks, Sarah. Morning, everyone. Obviously, I'm Nick. I'm a partner of Robinson Ralph Solicitors. We specialise in employment law only. So obviously, we're taking a really keen interest in recent developments in employment law, particularly the Employment Rights Act. So, just to give you some background then on the history of the Act. So, if you go back to last year when, well, 2024 now, during the general election, Labour obviously campaigned on the basis of making wholesale changes to employment law, which they were looking to implement within a very short period of time following the election. And they were going to look at implementing some of those in 2024 itself. But it didn't quite manage that. But there was the Employment Rights Bill, which has had some, which went through the House of Commons and House of Parliament at various stages, lots of discussion and consultation about that. And eventually, late last year, on the 18th of December, the Employment Rights Bill was given the royal assent, and that then leads to what we have now, which is the Employment Rights Act. So in terms of reforms, well, there's nothing really revolutionary in there, so there's no real new rights that have been introduced, but there are what I think are significant extensions to existing rights and obligations. It's important to remember that whilst the Act sets out various extensions and measures, they will only become law through secondary legislation or regulations, what we call statutory instruments. So those regulations should mirror the primary purpose of the Act. But that doesn't necessarily mean that what's in those regulations will be exactly the same as what it says in the Act. So in terms of what we're looking at today, we picked out what we think are the main changes. We're not dealing with them in date order as such, because there's stuff coming in during the course of this year and into next year, but we're really looking at things in terms of importance, and perhaps things that, even though it might be some time before the change comes in, there's certain things that you can be doing now as employers in preparation. So the first thing we're going to look at is unfair dismissal. Now, I think most people know this has been one of the real big headlines of the Employment Rights Bill and the Employment Rights Act. And eventually what we've ended up with is a situation where the current qualifying period for people to bring unfair dismissal claims has been reduced from 2 years to 6 months. So the only people that can currently bring unfair dismissal claims are those employees with as of the date of termination of employment, have 2 years continuous service. Now, the reduction to 6 months will take effect from the 1st of January 2027, and it will apply to people who have 6 months continuous service on or after that date. So that means effectively that people who employers recruit in June or towards the end of June, sorry, and starting in July, just being careful on dates. These are the kind of people that if they're still on your books as of January the 1st, 2027, will have protection from unfair dismissal. So obviously there's certain things that you need to be doing now in terms of processes, which Lisa will take you through.
Thanks,
The other
Nick.
thing to remember.
Oh, sorry.
Okay, just briefly, I mentioned probationary periods. The law originally was going to be that there was going to be statutory probationary period. That's not the case now, so we don't need to worry about that. In terms of the statutory cap on unfair dismissal compensation, well, that's actually been removed under the Employment Rights Act. So, as if you don't know, unfair dismissal damages are capped at either 12 months gross pay or a sum roughly around £118,000, whichever is the lower. So that cap's been removed. However, that is subject to some kind of impact assessment. So we'll see of the impact of that. Of course, because of the removal of the cap, that does bring into play people who, really big earners who might not have brought an unfair dismissal claim because they simply earned too much, ultimately didn't make it financially viable. So we'll have to consider whether that results in more claims. It perhaps also means that if you are faced with employment tribunal claims, then the potential financial exposure is massively increased. And that, I'm sure, will also affect any settlement discussions that you might have. Claimants might have unrealistic expectations about what their tribunal claims are worth. So I'm going to pass you over to Lisa. She's going to go through some of the steps that you might want to take in preparation for these upcoming changes.
Thanks, Nick. So for me, I think this one is the biggie, and we really need to be putting steps and processes to prepare for this in place now. So if I just talk you through some of those steps and what they would look like. So I think it goes right back to the beginning. So reviewing what your recruitment process looks like. That includes things like making sure you've got job descriptions that actually match the role and are like for like. We need to make sure that they are communicated to the employees. So through that recruitment, you need to ensure you optimize your questioning in interviews. So you really want to be getting that right hire from the start. The probation period itself, we want to make sure that that is a continuous process of reviewing how they're performing and that feedback is delivered regularly as well. So we really need to give an overhaul of what that first few months looks like in a role. Performance management is also going to be key in this. So if there is an issue with performance, then we need to make sure that our managers are trained and competent in kind of picking that up from the early stages. It's going to be a lot harder to manage someone out if they're not performing, if we don't have a clear document kind of as to what's being done up to that point. There are some things that you'll notice as we go through here that I'll talk about a lot. So one of them is looking at your current contracts and your handbook policies in place and making sure that they are in line with current legislation, and making sure that these are clearly and readily available to all employees so they know how you are monitoring performance and what the process is as well. And then the biggie is your capability of your managers. So they're the ones that are going to be implementing these processes. So we need to make sure that they're aware of the impact that not following the process may have, and that could be a financial implication or a reputational implication as well on that.
Thanks, Lisa. So the next change I'm going to look at under the Employment Rights Act is the change to the employment tribunal system. So under the Act, it's proposed, well, it will happen, is that the time limit for bringing tribunal claims will be reduced from the current 3 months. I think everybody understands that. Sorry, it will be increased from the current 3 months to 6 months. So people will have 6 months to start the ACAS early conciliation process and then bring a claim. This is likely to happen in October of this year. And I just want to cover the potential impact of this. So the primary limitation period is 3 months. An employee has to, by law, start the ACAS early conciliation process. That's mandatory. And the impact of starting that process, it stops the 3-month clock running for bringing a tribunal claim. And that can stop for up to 6 weeks. And then at the end of that process, subject to when early conciliation was started, an employee will always have at least a month to then bring their tribunal claim or issue a claim to the tribunal. So that 3-month period could actually be well over 5 months in the end for bringing a claim. So you can see here that if the 3 months is now extended to 6 months, and that 6-month clock stops ticking to take into account the ACAS early conciliation period, which has now also been extended to 12 weeks. Ultimately, you might have periods where people can be bringing claims up to 10 months after their employment's ended, or 10 months after the alleged discrimination that they're complaining about. Now, the impact of that is simply that employers are going to be left with quite a long period of time without really knowing what's going on. They might have to plan for claims, might have to plan for increased financial exposure. So at the moment, it's quite a short time scale for bringing claims, but that's going to increase significantly when this change comes in. So that's going to be October 2026. Lisa.
Thanks, Nick. So again, for this one, prepping for it, I think the first place to start is, again, with your contracts and your policies. So making sure that they are up to date and compliant with legislation. So the key ones that you want to be checking are going to be your disciplinary and your grievance, and making sure that they're clear and they're easy to follow. And again, that employees are able to access them and are aware what the process is. Record keeping is going to be really important, as well. As Nick says, the time to bring a claim is going to be a much longer window, so it's really important that we've got an accurate recording of what has happened should you need to rely on something. So detailed records of, if that be a performance review, somebody's attendance, any warnings that are issued, or even if it was an informal meeting, make sure you've got a process in-house to document that as well. It also goes back again to training your managers. So they're the ones that are going to be responsible for ensuring compliance, for keeping these detailed records, for having potentially difficult discussions. So again, they need to be confident in how to handle that. One of the other things as well is acting early on in disputes. So if there is a grievance or a rumbling that somebody's not happy, the earlier you can jump on that and try and resolve that, the better. So again, that comes down to training your managers so they're aware of what to look out for and how to handle those difficult conversations. And then also just periodically reviewing risk within your business. Are there any potential employment risks, and do we have policies in place to cover those?
I think just diverting slightly, I think Emma Kay's just posed a question in the chat. That's something that we want to look at this point. Shall I deal with that one?
Yeah, if you want to. I was just going to reply to Emma. Obviously, a question was just, does it mean that now with probationary periods, we should be implementing performance improvement plans instead of after, which I'm sure, well, Lisa, you might be able to head that one off in terms of onboarding processes and really keeping more documented records than maybe companies do currently. I'll let you handle that question.
Yeah, so I think within that probation period, there needs to be a clear process in place for how we're going to review performance. So I think it goes back to having that job description first. That needs to be communicated either ahead of them starting with the job advert, again when they start as well. And then the review process, what we don't want to be doing is to get to the end of that probation period and then sitting down to say, how do we think that's gone? So we want regular check-ins, whether that's weekly, then dropping down that frequency as you go on, but we want to make sure that they are regular check-ins. If somebody isn't performing and we're picking that up, then we need to at that point be addressing that, and that could be through a performance improvement plan and setting those clear objectives. So for example, okay, we're not seeing the sales that we need to come through. What I need you to focus on over the next week window is X, Y, and Z, and we'll sit down on this day and we'll go through it and monitor success. Does that help at all?
Well, we've got some thumbs up to that, so
good.
I would say some of these points are also covered in the guide that I've mentioned in chat, so there are some of the practical tips of what you might need to be doing.
Okay.
Back to you, Nick.
Right. The next change then that we're looking at is in relation to the concept of or the legal duty to take reasonable steps to prevent sexual harassment at work. So the current legal position, as it's been the case since October 2024, is that employers are under a duty to take legal steps to prevent sexual harassment. Now, that's a mandatory obligation. And it doesn't in itself, if an employer fails to do that, it doesn't necessarily mean that there's a freestanding employment tribunal claim, because there isn't. But there's two reasons to do this. One is that there's a mandatory obligation under law to do it. But secondly, it obviously will have a positive impact on your workplace, which Lisa will go through. But any failure to do this, in the event that an employee brings a successful sexual harassment claim in a tribunal, means that any tribunal award can be increased by a percentage of up to 25%. So, and of course, there's all kinds of issues arising from that. Well, negative publicity, losing tribunal claims, all those kind of things. So that's the current legal position. But as of October this year, that duty to take reasonable steps will be extended to the duty to take all reasonable steps. Now, we're yet to see really what difference that might make, because arguably, if you don't take all reasonable steps now, then a tribunal may find that you've not taken reasonable steps. But clearly, there's a much more absolute obligation coming into place in October 2026. So you have to take all reasonable steps to prevent sexual harassment in the workplace. Unfortunately, there's no statutory guidance on what reasonable steps are or what all reasonable steps might be. There is guidance produced by the Equality and Human Rights Commission on reasonable steps, which we find to be useful, which I'm sure that tribunals will have some regard to. But that's the first issue here. The second issue we're looking at then is that the Act introduces the concept of a complaint of sexual harassment now amounting to a protected disclosure or effectively whistleblowing. So people who complain of sexual harassment will now have an added layer of legal protection. They'll be regarded as whistleblowers. And obviously that means they'll be protected from being subjected to a detriment or being dismissed for having made that protected disclosure. Now, the law probably already protects people in that respect by way of victimisation claims under the Equality Act. But quite clearly, if somebody does make a complaint of sexual harassment and then they are subjected to a detriment, you can see how now they're going to be lining up several tribunal claims in the event that things don't go well for them. And the other impact of this is it could mean increased tribunal awards as well. The Act also seeks to reintroduce effectively the concept of the employer now being liable for third-party harassment. So if one of your staff is subjected to harassment by a third party, that could be by a customer, a member of the general public, the employer could be found liable for that harassment. And really, this is key, isn't it, to trying to show that you've taken all reasonable steps to prevent the sexual harassment, which, if you look at the EHRC guidance, there's details in there how you might do that, things like risk assessments, impact assessments, just working out who your staff come into contact with and where there might be any risk areas or increased risk areas for the potential for sexual harassment. The Act is also looking at the possibility of a ban on what we call NDAs, non-disclosure agreements, and the purpose of that really is to ensure that employers are not able to keep confidential complaints of sexual harassment and things like that. Ultimately, I think the issue here has been dealt with over time, because if any of you are familiar with settlement agreements dealing with the settlement of employment related complaints or the termination of employment, there are confidentiality provisions in there, which we as solicitors, for example, have to be careful of, because we have our own professional guidelines dealing with those things. But we are advised, and will do professionally anyway, to ensure that no confidentiality provision or non-disclosure agreement prevents somebody from making a protected disclosure in the right circumstances. So it'll be interesting to see how that pans out, really, what any ban looks like and what people can't talk about. So those are the issues in terms of harassment at work. So I'll pass you over to Lisa and she can look at steps that employers take.
Nick, just as Lisa's moving the slide on, there's a question just from Angela in the chat, just to say, is this covering sexual harassment only or other areas of harassment?
Right, so at the moment it's sexual harassment, but it's a good point because it seems to me that it's going to be a logical step at some point in the future that it's going to cover the other protected characteristics, disability, age, race, those kind of things. I think most employers anyway will already have some kind of zero tolerance approach to harassment on all grounds. But that's not currently, there's no current law making it mandatory for the employer to take all reasonable steps to prevent that harassment. So at the moment, this is what we have, but I think it's not going to be that long before that's extended to all protected characteristics.
So with regards to how we can plan and prepare for this, again, it goes back to updating those policies and processes that are in-house. We want to be making sure that sexual harassment is covered within our whistleblowing policy and also including a part around third-party harassment as well. So if that's clients, contractors, visitors, a review of NDAs that are maybe in use currently as well would be advisable. And we need to make sure that reporting channels are clear and that all of this information is communicated across your employees. Another part of it is to ensure we're delivering regular training, and that needs to be meaningful training as well. So we want to stay away from kind of a tick box exercise, and we want to be keeping, again, evidence that people have attended this, that they've had refreshers as well. You'd also be worth having a look at your business and picking out any key areas of risk and putting preventative action in there. So maybe if there's some roles that are customer facing or they're at events and they're doing loan working, what steps are you going to put in to ensure their safety? If you do get a complaint, again, make sure it's acted upon quickly and in line with your processes. So that again goes back to having competent managers that are well trained in how to handle these as they come in or if they do come in. And a big piece is around the culture that you're promoting within your business and the values that you're representing. So having people kind of aligned with that positive culture.
I think there's a couple of questions coming on those topics, haven't they? Do you want me to pick up the first one that Jennifer's sent in?
Yes, I'm just replying to the one on training, so I'll let you head off Jennifer's.
All right, great. So Jennifer, so your question is, if a ban is implemented on NDAs, I presume, I do think there is a risk that employers won't want to enter into settlement agreements because ultimately people will still then be able to repeat the allegations that they've made about sexual harassment. So, the effect of a non-disclosure clause is then lost, isn't it? Really, in many, whether that's right or wrong, I should say. That's not the point I'm making, but I can see that employers may not find it as attractive to pay people off if that is something that they might still pursue, albeit not in an employment tribunal. Whether or not that's actually happened, we'll have to wait and see, but that's the general view. It does make settlement agreements perhaps less attractive now than they would be before.
Perfect. I've dropped a response in on there's a couple of questions around training, but maybe just to add to those. Where Lisa's talking about not being a tick box, we have to make sure that the training is covering not just a general awareness on sexual harassment, but covering the enhanced responsibility of the prevention. So it doesn't have to be in person. You can still utilise online training. There's loads of video-based training out there, or you might develop something yourself in-house. It's just making sure it covers the key responsibilities. And I think the other one was, again, just asking around training. There is a part of this is that enhanced responsibility, which is to make sure that your workforce is aware. So a policy might not be seen as enough anymore. So that's where training does become more critical, to make sure you can demonstrate you're not just saying on a piece of paper or an online policy what you should be doing. you're actively trying to train people on awareness and prevention of sexual harassment in the workplace. So hopefully that confirms for you. Yes, we've got some thumbs up. I'll let you move on, Nick.
Right. So the next changes under the Act relate to family-related leave. So this is actually a very recent change because this week it was announced what the law is going to look like on this. So the current position in relation to paternity leave is that it's only applies to people with 26 weeks service. But as from the 6th of April this year, that's going to become a day one right. However, the right to statutory paternity pay will only apply after 26 weeks service. So it'd be interesting to see how many people take that up, given that it's unpaid. But having said that, sorry, it's unpaid for people with less than 26 weeks service. But even then, the paternity pay might not be attractive enough for people to take advantage of that right to time off. The current position in relation to parental leave is that it's only open to people with 1 year's service. But again, as of the 6th of April this year, that's going to be a day one right. And the right remains that it's going to be 18 weeks unpaid parental leave with a maximum 4 weeks to be taken in any year. One of the extensions, though, to this right is that it's expected that as from January 2027, there's going to be enhanced protection from dismissal during or after these family-related leaves. So there's no firm details yet on what that's going to look like. We've already had some stuff around enhanced protection for people on or returning from maternity leave. So I expect it's going to mirror that, really. But as I say, that's not until January 2027. So there's still plenty of time for information on that to come out. Lisa.
Thanks, Nick. So again, one of these, the first thing is to look at your policies and contracts and update them where needed to make sure that they're in line with the changes. One of the things with this is obviously the 26 weeks service is going to be gone. So as a business, you're going to be getting those requests for these types of leave much earlier in somebody's kind of employment with you. So you need to be prepared for that as well, and how that would impact maybe their development if they're new into the business. Train managers to make sure that they're aware of the leave entitlements and how pay is affected with that as well, so they can communicate it clearly. What we also want to do is ensure when managers are handling it, they're handling it in a way that doesn't show kind of indirect discrimination to people new into the business, then requesting to take however many weeks off under this type of leave. We need to look at how we will cover absences. So if somebody does go on parental leave or paternity leave, what are the contingency plans within the business for covering their areas of work, whether that be kind of cross-training or having a gap for 2 weeks. And then also along with what happens on their return to work as well. So how do we integrate them back in? Is that through a phased return, flexible hours? Are we conducting the return to work interviews with them to let them know what's kind of been going on in their absence and things like that? Make sure that this is communicated again to all employees, so they're aware of these changes to entitlements, and that they know that it's ready available should they wish to use it, and how they go about applying for that as well.
There are a couple of questions, but I will just head them off in the chat if you two want to move on. I'm just conscious of time.
Sure. Okay. So, go back to this. Flexible working. So, some changes here in terms of flexible working. So the current position is obviously that employees have a right to request flexible working. So that doesn't mean they have a right to flexible working arrangements, but they have a right to request flexible working arrangements. So as we know, the employer can refuse that request, but can only do so lawfully on one of 8 statutory grounds which are set out in regulations. And in many respects, it's a very prescriptive process. The employer has to follow a process, including considering the request, meeting with the employee, providing the decision, all within a prescribed time scale. But at the moment, the issue of reasonableness doesn't apply to this situation. But as from 2027, likely to be in January of next year, then the Act introduces this concept of any refusal of a flexible working request must be reasonable, and the employer must explain why. So clearly, there's going to be some scope for claims here, because ultimately, if people make flexible working requests, they're generally unhappy when they're turned down. But at the moment, their ability to pursue the issue is only really through one of two channels. The first is whether or not there's been a failure to comply with the statutory process on flexible working requests, which ultimately is a limited right and gives rise only to a relatively small amount of compensation. Or if the refusal of a request, it may amount to some kind of indirect unlawful discrimination. Typically females with childcare commitments. That's the biggest risk area for employers. But there are also other areas where indirect discrimination might apply if a flexible working request is turned down. But the key issue here is that as from next year, employers are going to have to make sure that refusals are reasonable and be in a position to explain why. Lisa.
So I think one of the main areas, again, is just reviewing your policy that's in place for this. Your managers within the business are the ones that are normally going to be handling these requests as and when they come in. So make sure that they're familiar with the statutory reasons for why they can refuse a request, and that they're confident with documenting that as well, following the process and keeping a detailed record of what that outcome is. So the training for the managers on this is going to be a big one.
Okay, so the next thing we're going to look at is the concept of fire and rehire, or in a more legal sense, it's where employees have their employment terminated with notice and are re-engaged on varied or different terms. Now, employers typically use this in situations where they want to make changes to terms and conditions, perhaps to restructure a business, or to change some form of working hours or something like that. And in order to do that, they have to get the agreement of the staff following a period of consultation. Now, you will get occasions where there's a failure to agree, that the employer cannot get the agreement of its staff to the changes. And their only real option then, other than making a unilateral variation of contract, which we'd never advise, obviously, their only option then is to terminate the employment with notice and offer re-engagement. Now, that doesn't involve a breach of contract in itself, but it does give rise to the possibility of an unfair dismissal claim. And depending on the facts and circumstances and the number of employees involved, it may also involve application of the rules on collective redundancies. So for those reasons, we call this a nuclear option. So it's not often used. However, it's not uncommon with larger employers, particularly public sector and quasi-public sector employers. So what the Act does is it seeks to make unlawful aspects of what we call fire and rehire. So it's going to make it automatically unfair to dismiss somebody for failing to agree to what the Act described as a restricted variation. So that's a restricted variation to the contracts for employment, and that is in relation to pay and benefits, hours of work, time off, or unilateral variation clauses, which I think are problematic in themselves, but that's what the legislation says. And then it will also deal with any other kind of variation which is specified by the Secretary of State. So I don't know how many of us here have, I mean, obviously I advise on these things, so I do come across them every now and again. I don't know how common it is in practice. As I say, it's the nuclear option. But on the next slide, even though it is automatically unfair to dismiss, there is, if you can just forward one, Lisa, that would be good. Yeah, and then it is an exception, not a defence in law, but an exception, that if the reason for the restricted variation, so not the dismissal, it's the reason for the variation to the contract was to eliminate, prevent, or significantly reduce or significantly mitigate any financial difficulties which at the time of dismissal were affecting or were likely in the immediate future to affect the employer's ability to carry on business as a going concern, or if the employer is in the public sector, the financial sustainability of carrying out the employer's statutory functions. And in all the circumstances, the employer could not have reasonably avoided the need to make a variation. So, looking at that wording, it suggests, doesn't it, that there has to be extremely exceptional circumstances, almost always going to be financial circumstances, where an employer is going to be in a position to fire and rehire, essentially, and be able to rely on that exception. So clearly, this part of the Act is going to make it much more difficult for employers to change terms and conditions of employment if staff don't agree. Now, that's going to be particularly difficult in unionised environments because obviously they're going to be more aware of the issues here. So that's obviously a problem if employers want to go down that road. And then the last issue I want to raise here on the following slide. The Act also makes it automatically unfair to dismiss and replace with an employee with a non-employee who's going to perform substantially the same duties as that employee. So at the moment, all kinds of issues can arise here. So, for example, in a redundancy situation, an employer may dismiss for redundancy an employee because they don't need employees to do that particular kind of work anymore. And they might be replaced with contractors or something like that. That seems to fall foul of this new provision here. So we'll see how this works in practice. Obviously, we're looking at a position where we don't have the regulations yet, so we don't really know how it's going to operate. And there's going to be ongoing consultation with this, I am told, and then the change is going to be in October 2026. So there's quite some time for this to come out, but we'll just have to see what happens here.
A question, just to interrupt,
yeah.
Nick, that we had from Cara is just a question around if a business is harmonising terms and conditions, would that potentially be now considered fire and rehire?
Well, if that involves termination of employment and offer of re-engagement, then yes, and then these rules are going to be applicable to that kind of situation, and you'll only be able to rely on the exception in those very exceptional circumstances, which appear to point to quite dire financial prospects for the employer, I suppose. I think also the reference to harmonising suggests, maybe after a TUPE transfer, I suppose. Yeah, I can see some overlap there. I think that's going to be problematic. I mean, obviously, the issue of harmonising in itself is slightly problematic from a TUPE perspective, but the changes to the Act seem to suggest that unless you're able to agree the changes with the employees who are affected by it, then the employer is going to face some real difficulties in achieving that harmonisation. If you ultimately want to dismiss and offer re-engagement, it's only going to be in a very narrow set of circumstances that you can do that.
Perfect, thanks. Lisa, over to you.
Thank you. So, yeah, looking to prepare as always, it's reviewing those contracts and assessing where there might be risk within the business. Consultations are going to be massively important to ensure that you're starting those as soon as you can. We don't want to be rushing through the changes. So whether that's individual consultations or collective consultations with what the proposed changes are. Again, keeping records of all these discussions, so documenting everything. So if there are any objections or feedback, make sure there's a clear record of what they were and kind of your response to those as well. Take all concerns that employees raise seriously. If it does get as far as going to a tribunal, that's one thing that they will look at. Was that consultation process genuine and thorough? Also consider, if you are thinking about dismissing, are there any alternatives before you get to that stage? So is there redeployment or role changes or a more flexible option within the business elsewhere? What we want to be doing is not rushing through changes. So the sooner that we can start this, the better, to really get that buy-in. And it's how you're going to communicate with your employees as well. So start that communication early, explain thoroughly kind of your reason behind these changes and what you're hoping to achieve from implementing them. Be professional, make sure that you're transparent and talk about kind of how it will impact them. And then just make sure that your planning stages as well are thorough. And again, it goes back to that document, so make sure there's files kept on all of that.
Right, thanks, Lisa. So the next change we're going to look at is that of 0 hours contracts. Now the government and trade unions have made no secret really of their dislike of 0 hours arrangements or casual work arrangements. So the Act will introduce, probably in 2027, we're yet to see the full details of this because we don't have any regulations, but it will introduce provisions dealing with the guarantee of hours or contracts for people which is after a reference period which will be determined, and that's based on the actual hours worked during that period. So prior to this, there was a concept of giving people predictable hours, but that's now morphed into this, where there's going to be guaranteed hours after a period of where people have worked out and they can be worked out then. There's going to be reasonable notice of a change to or cancellation of shifts. So one of the main issues here is that people have not been told that shifts are either changed or cancelled. They've turned up to work. Typically, we hear about stories about people turning up to work for Amazon. When they get there, they find there is no shift. They've travelled to work quite a long way at some expense. When they've got there, they found there's no work, so they're actually out of pocket for that day. So the Act's going to introduce provisions dealing with that. There's going to be an exception in relation to seasonal or temporary workers, because obviously the nature of such work is going to be extremely short term. Perhaps a huge generalisation here. Perhaps that work is undertaken by people who have no issue with shall we say, more relaxed working arrangements. The Act will also introduce the concept of compensation for cancelled or curtailed shifts. So if people do find themselves in a situation where the work or shift is cancelled and they're not given sufficient notice, employers or hirers or agencies will be responsible for compensating those people. So as I say, we're yet to see the full details of these arrangements, but they're likely to be in next year in 2027. Lisa.
So with regards to implementing steps and how you can prepare, so one of the things is tracking your hours and guarantee contracts after the reference period, like Nick mentioned. So you need to make sure that you are accurately calculating the hours worked within that reference period, and if you need to update a contract, that is done once that threshold is met. We also mentioned the reasonable notice, so defining what that reasonable notice is if you change or cancel a shift, make sure that's documented within the contracts as well and that it's adhered to. Nick mentioned exceptions for seasonal or temporary workers. So again, if there is an exception, make it clear within your contracts kind of who that applies to and when as well. What I would be doing at the minute is auditing what's currently contained within your current 0 hours contracts, kind of ahead of this change coming into place as well.
There's a question there from Jennifer. If I just pick that one up, it's because it's something I dealt with. So what would be sufficient notice for cancelling shifts? Well, at the moment, in terms of what the Act requires, we don't know because the regulations aren't in. So at the moment, 0 hours workers are kind of unless there's some contractual provision dealing with notice for cancellation, then no notice is required. And that, obviously that might sound unsatisfactory to certain people, particularly in hospitality where things can change very quickly. So the issue about cancellation is less of a legal one, I think, at the moment, but more one of practicality and maintaining the goodwill of your staff ultimately. Right. The next issue then is trade unions. So this probably isn't going to apply to lots of people, However, the big change here is that the Act will provide for trade unions to have access to workplaces, not employers with fewer than 21 workers. But it does mean that unions will have the right to request access to the workplace, primarily for the purpose of doing things like recruiting members, negotiating on terms and conditions. There's likely to be a strict process dealing with the access requests. There'll be protocols put in place for how that process should be dealt with. I understand the government is going to be producing templates for dealing, setting out the basis of the request, the reasons why, etc. Now, I think the main concern for employers here is going to be this essentially. The protocols, my understanding is they're going to be quite strict, and if there is no agreement to the access request, then the trade union can apply to the CAC, the Central Arbitration Committee, who will then consider the request. And if the employer doesn't comply or doesn't engage in the original request process and meet strict time limits, they may find that trade unions have access to their staff almost unfettered. They have no say in that process. So this change is likely to come in October 2026. We don't know the full detail yet, but what we do know is there's going to be a process, and employers need to now be thinking about, how they're going to set themselves up for dealing with these requests, just to make sure they don't miss out on dealing with them, and then finding that they're subject to engagement with the trade union, which they didn't want initially, or they have no say in. And then just briefly, that there are other changes to trade union stuff, such as at the moment, in order for there to be a lawful ballot, there has to be a 50% minimum turnout. That's going to be removed, and now there's just going to be a simple majority required of those balloted, rather than there be thresholds of the number of staff who are involved in the ballot. Again, that's all October 2026. So we await regulation of that, so we'll see how that pans out. Lisa.
Thanks, Nick. So I think kind of preparing for this one is really just understanding how that new access rules will affect you. So as Nick said, quicker, easier and cheaper. So we need to prepare and ensure that the managers understand the implications for negotiations and agreements. So make sure that they're confident in having these consultations. Review internal communications and employee engagement practices. Prepare as a business for possible union involvement and workplace discussions, and make sure again that we're documenting everything, so there is that clear paper trail of any discussions that happen. Make sure your managers are confident in having discussions with the union reps and those difficult conversations as well, and also consider how you're going to respond to any requests as a business for union recognition.
I've headed off any other questions in chat, so I'll let you move on, because I am conscious we've only got 10 minutes or so left.
All right, fine. Okay. So collective redundancies. So for those who haven't been involved in these before, the current position is that any employer who is looking to dismiss as redundant 20 or more people at any one establishment within a period of 90 days, well, the collective redundancy regime applies. And what it essentially means is that the employer has to consult with either the trade union or elected representatives of the affected employees about a whole host of matters. So it's not simply like an individual redundancy situation. They have to consult and agree about lots of things, such as how redundancy is going to be dealt with, how the consultation is going to take place, redundancy selection criteria, loads and loads of things. And it's a really, really difficult process to get through. And the problem is that if an employer fails to comply with its duties here, it does run the risk of tribunal claims for what we call protective awards, which are currently worth up to 90 days pay per employee. So what the Act seeks to do is to provide an additional threshold to this 20 redundancies at any one establishment. So it's going to mean that where the proposed redundancies reach a prescribed level across the employer's business, then the collective redundancy regime will apply. Unfortunately, at the moment, we don't know what that prescribed level is because there are no regulations in place. What it seems to suggest is that it's no longer going to be the issue that these redundancies have to be at one establishment, which at the moment essentially means one place of work. So we'll see if that then is spread over different workplaces, but the numbers might not increase. And then the other significant change here is that if the employer does fall foul of these regulations, then that maximum protective award per employee will be increased from 90 days pay to 180 days pay. So, you know, that's quite scary stuff. That's looking to come in 2027. And, you know, clearly, we await the regulations, but if things go wrong, then the financial challenges there can be quite horrendous. Actually, in my experience, we don't see many of these claims, but where we do, they are obviously very expensive. Lisa.
Thanks, Nick. So again, big thing is just getting your head around and understanding the new redundancy thresholds and triggers and what this means for you. And managers within your business that will be responsible for leading any collective consultation processes. We need to ensure that if we are going into collective consultation, that it's done early enough to comply with legislation with regards to kind of 30 or 45 days prior to any redundancies taking place. If you need to engage employee reps or unions, again, make sure that is done within the required time frame. Make sure the managers are trained on the process and are aware of the implications it may have on the business if they don't follow in line with these new legislation as well. When looking at redundancy as well, you just need to consider, are there any alternatives that would avoid us having to go down the redundancy route? And then prepare for the increase in maximum protective awards again. So what this risk may look like to you as a business.
Right, the last slide then. So we picked out what we think are the biggest points here, but there are still some things which are going to be coming in the future, which might not be in the Act, but will certainly be relevant to all employers. So the first bullet point there is pay gaps. So the Act does provide for future regulations, which are going to require employers with 250 employees or more to develop and publish what we call equality action plan, showing what steps they're taking in that regard, and really to show what they're doing in relation to what we call prescribed matters related to gender equality. And that's going to mean things like publishing prescribed information relating to those plans. That's what the Act requires them to do. So matters relating to gender equality, that's going to be things like the advancement of equality between male and female employees, and also addressing things like pay gaps. So obviously that applies to big employers, and it will also have to deal with employees who are going through the menopause, which is the next bullet point. So currently menopause is not a protected characteristic in itself. As an extension to this topic, menopause can be a disability in the Equality Act. It can obviously be relevant to the protected characteristic of sex. It can be relevant to the protected characteristic of age, but there's currently no standalone claim for menopause discrimination. Quickly, the next bullet point is single employment status. So the government is proposing to consult having a single status of worker, and then that's as being different from the genuinely self-employed. So essentially a two-part framework for dealing with employment status, which is different to what we have now, which is employee, workers, and that kind of things. That would represent a massive shift in the law and require changes to a whole host of legislation. So I think that's going to be some time away if ever it arrives. The government was previously talking about changes to post-employment restrictions or restricted covenants. There's going to be a working paper published on that, just really considering what kind of restrictions are in place and what changes might be made, whether there's any kind of statutory limit on things like non-compete clauses or bans on such clauses altogether. So we'll await that. I understand that's going to be in February sometime, so we should see when that comes out. So there's nothing currently in the Act about that, but there's going to be a working paper. We've also got the right to switch off. I understand the government's plan is to implement that as part of a code of practice following a period of consultation. That's rather than having a specific right under the law to switch off. I think that's in the context of working from home and the ongoing reviews there. And then lastly, a point that for some reason is not in the slides, but actually it's quite a significant change, is that as of April, as we probably already know, the right to statutory sick pay or SSP will be a day one right. People don't have to wait until the 4th day of sickness absence before they're entitled to SSP. Lisa.
Thanks, Nick. I think just to add on to kind of those points that you covered there, obviously, as we've said throughout all of this, it's updating policies and making sure that those dealing with any of these changes are aware and are confident with how to deal with them. I think the biggest one is the SSP that you mentioned at the end there as well, and the impact that that may have on the business. You may find an influx of absences where SSP will be payable from day one. So I think it's really about looking at the processes that you've got currently and are they robust to deal with managing absence, and what are the processes involved with that. So things like return to work, whether you look at implemented Bradford factor scoring, things like that. And if you are looking to change the process, communicate that early so that employees are aware of what that means for them.
Perfect, thank you. Just to kind of wrap up, I think we've addressed all the questions that have come through, and I've mentioned a few times in the questions. Lisa, if you'll just pop a slide on, one to the next slide, please. This is a timetable that we've put in a guide, and anybody that's registered for today's webinar will get this emailed out. And what we've done is give you the timetable in date order. There's a summary of what each of those changes are and some of the tips of how to best prepare to implement those changes within your business. There's also the contact details within the guide that are on screen now, so you don't have to be scrabbling around for a pen to get them. But if you obviously want to get in touch with Nick, as he mentioned, his firm are employment specialists. That's all they do. So Nick, I'm sure, and his firm will be quite happy to help with any issues that you might need guidance on. Or equally, Lisa and myself are available if there's anything you might need on a day-to-day basis. So I think for now we've ended bang on time. So thank you, Nick and Lisa, for covering such a lot of content, because there are so many changes within the hour. And you will all receive notifications also that when the recording's available. So if you want to rewatch any of this then, or forward that on to anyone, please feel free. So for now, I'll end the webinar. Thank you all for attending.
Thank you.